The first case to come before the court this morning is ATCL 1 LLC versus State of Ohio Board of Pharmacy. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, let me know when you get started. It helps a little bit. I know you can keep the time by yourself. If I'm operating this machinery correctly, it should appear. But we'd also like to know if you're reserving any time. Please don't use the names of victims or minors. I don't think it's relevant to this case, but we make that advisement each time because we are recording today's proceedings. They will appear on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
I would like to reserve 5 minutes, please.
Thank you.
If it may please the court, opposing counsel, my name is Henry Appel. I am with the Attorney General's office and I represent the appellant, the State of Ohio Board of Pharmacy. The issue that you have before you today is whether the State of Ohio Board of Pharmacy abused its discretion in saying that ATCL came in 5th place in Summit County when applying for a medical marijuana dispensary license. The trial court erred by not correctly applying Ohio Administrative Code 3796 6-204A in 2 ways. And before I go on, all the rules I am mentioning here are former rules. In September, they all got amended. So instead of former every time, I'll just tell you that. The first way that the judge violated the rule, violated that rule, did not even purport to apply the abuse of discretion standard found in Dennis-Clarko. And the second error was did not place the burden of proof on ATCL to show prejudice. The problem we have here is that there were 22 applicants in Summit County. KDJOH was the 3rd highest scorer, and there were only 3 applications that were going to be awarded, licenses to be awarded. They came in 3rd. Their score was 175.5. The score that was here was 170.3. So they have a score of 170.3. They had to make up roughly 5.1 points. Unfortunately, first off, the first issue is what standard of proof should have been applied to the question of law. And the standard should have been the abuse of discretion standard found for competitive bidding and competitive scoring, identified in Dennis-Clarko. And I would ask this court to look at the supplemental authority I filed back in January, citing a recent decision from the 10th District Court of Appeals in JG City, which found that in a medical marijuana dispensary case, the appropriate standard of review is going to be abuse of discretion from and they apply the Dennis-Clarko standard. So the only appellate court that has ruled on this definitively in terms of a dispensary case or a cultivator case has been the 10th District, and that was in the with the JG City. Ironically, when you actually look at the ATCL's brief, about what the proper standard is, they identify 2 cases, Executone, which is a Supreme Court case, and Aetna Healthcare, which is a 10th District case. Both of those actually applied an abuse of discretion standard. And frankly, and keep in mind, even though we're on an administrative appeal, and Dennis-Clarko was seeking an injunction, courts apply the same legal standards in administrative appeals and then as they would if they were going through the court system normally, through a different type of filing, unless some statutory reason to do otherwise. But perhaps the biggest problem we have here is prejudice. ATCL has no reasonable theory of being able to show that there is prejudice in this matter. As a matter of issue of fact, there's no question that we had the same set of scores score 5 of ATCL's applications. There are some of the questions and answers had identical answers. Some did, some didn't. And sometimes those evaluators made a mistake. They were not superhuman. They sometimes gave a bit higher scores. Sometimes they gave a bit lower scores. The reality was there was not 100% consistency between the scoring, and everyone acknowledges that should have happened, or that was what we would hope would happen when evaluators are scoring these questions. But with that said, ATCL isn't able to show prejudice. They've come up with 2 different theories on how to show prejudice in their brief. First, if you look at page 9 of their brief, that's PDF page 13, they indicate that they should be awarded an additional 10 points. But the approach they use there is difficult at best. They identify any time that there's a gap at all between the top score and the bottom scores. But they don't make any distinction as to whether ATCL got a lower score or a higher score. The best question to look at to show the absurdity of this one is question D 9.2. And on that question, ATCL got a score of 8.5. Curated leaf got a score of 7.3. That means ATCL got a higher score, 1.2. They are in essence asking you to raise that score from an 8.5 to a 9.7. They want our existing difference to be then added on a second time. So even though the score is already higher, 8.5 to 7.3, just because there was a difference means in their mind that there should be a difference, should be repeated a second time. And that methodology doesn't make sense. The other approach they have, I would tell you how, if I understood it, I've worked very hard to try to understand their method, but what is very clear is what they want to do is anytime that an evaluator gave a higher score to a curative leaf application, that ATCL should get its score raised as well in some way. But keep in mind, everyone admits sometimes evaluators gave ATCL a lower score than its sister companies, and sometimes it gave a higher score than its sister companies. That approach makes no distinction, no approach doesn't do anything to recognize that sometimes ATCL got actually a higher score than its sister companies.
Counsel,
yes.
I have a question for you. These inconsistencies, I was going to say alleged, but they're not alleged. These
Not alleged.
inconsistencies, did they also occur with the scoring of the other applicants?
Yes. We had another case from, that actually went to appeal, Ohio Relief 2, that went to the Court of Common Pleas in Franklin County. And I cite that court case in my brief. And the judge there said, you have to just understand that sometimes, there wasn't any allegation of bad faith or anything else. Sometimes simple mistakes will occur. And with the abuse of discretion standard, simple mistakes are not enough to warrant relief.
And what about within the other applicants who actually scored higher than ATCL?
I don't know for sure, but I would not be surprised if KDGOH didn't have a higher score, has some variance because they have a sister company called WGB. I think 127OH had won the highest score, and I know they won 5 applications statewide, but we did not review that, and that's not on the record specifically.
Thank you.
But in terms of just the Dennis-Clarko standard and abuse of discretion, what we need to look at here is, did the board substantially comply with its request for applications? The request for applications said that there would be 23 scoreable questions, scores between 0 and 10, teams of evaluators. The board did that. There is no allegation or evidence of bad faith or collusion or any shenanigans or fun and games by anyone to try to tip the scales. You don't even need to get to the prejudice question because the first question is, was there a mistake at all? And at least in terms of the Dennis-Clarko standard, the answer is no. So under those circumstances, the appropriate step for this court to take would be to reverse the court below and say there was no error, but even if there was error, it should not have found prejudice. And with no prejudice, there should have been no further steps.
Let me ask on the nature of the scoring. You say you've got 23 questions and multiple scores. Did you have the same score for the same question for everyone? Did Wimberley always score question 1 for every applicant, or did Wimberley get everybody's applications and scored all of the answers, and Way got all the applications and scored all the answers?
There were 4 sections.
Okay.
Jesse Wimberley scored all of the business plan section questions and all of the security plan section
Did
questions.
anybody else score those same questions?
Yes, there was at least 5 scores for every applicant who applied, but most of the time it was 7.
So with the 5, do you average those 5 scores?
Yes,
Okay. So it's not that they're stuck with Wimberley's score only on a particular question.
that's correct.
There are other individuals who have scored that same question.
Yes, I believe there were 7 evaluators for all the, for the business plan and security section, and 6 for one of the other 2 sections. But I don't remember that name. But yes, that's the way they do it. They average, and if someone's out because they're sick or whatever, that's what happens. I do know that honestly, part of the reason they had the variation in the score was there was one evaluator who did not score ATCL's applications for the security plan. And so there were 7 for ATCLs, but only 6 evaluators for for curative leave. But it's hard to tell what impact that made. Their case is wholly built on sometimes the evaluators did get different scores.
But you could see that ATCL score of 170.3 is in the range of approvable applicants.
Absolutely. If they had a higher score, or the other 4 applicants above them had lower scores, they would be operating medical marijuana dispensary by now, and hopefully do a good job at it. There's nothing here saying these are bad people, they're not fit, or there's anything wrong with them. The problem is we had 376 applications statewide. We had 22 in Summit County for 3 spots. I mean, there's gonna be 19 losers. It's no matter how you slice it. It's just the unfortunate nature of having more credible quality applicants than you have available application spots.
And counsel, you are now at 4.5 minutes left. You may continue or reserve that 4.5 minutes.
Thank you. I'll reserve the rest of my time.
Good morning, Your Honors. Matt Duncan, representing the appellee, ATCL 1 LLC, who I'll be referring to as ATCL. May it please the court. This case is about consistency. Consistency in scoring was one of the requirements chosen by the State of Ohio Board of Pharmacy to evaluate medical marijuana dispensary license applications. That is not disputed by the state or the board. In the trial court's decision, the judge cited to testimony of senior counsel for the board, Aaron Reed, who admitted that the evaluators that the board used to score the applications were trained to score the applications consistently. She further admitted that evaluators were trained to score answers to the questions with the same score if the same answer was given. The state does not dispute that, and it's not disputed that in the briefs. Here today, the state argued a couple points, which I'll focus on first in my response. First, the state tries to argue that the Danis standard of abuse of discretion applies. As we set forth in our appellate brief, the Buckeye relief decision is more applicable to our case than the new case that the state has supplemented after briefing was completed, which was the J.G. City versus State of Ohio Board of Pharmacy. And in Buckeye relief, the 8th District Court of Appeals specifically did not apply the Danis standard. The court, in our case, also did not apply the Danis standard based on her application of Buckeye relief. In Buckeye relief, the issue there was that the board, like here, inconsistently scored application questions. In Buckeye relief, it was only one question that was an issue. In our case, it's 15 of 23 questions that have been inconsistently scored by the board. So when it comes to the question of prejudice, as stated in our brief, the prejudice standard does not apply here. But even if the court were to apply prejudice, the record's clear that ATCL has been prejudiced by the inconsistent scoring. 15 of 23 answers being inconsistently scored by the board cannot meet a substantial compliance standard under any measurement. And as the record has indicated, and as the state has even admitted today, that being in 5th place in the scoring that was completed, if ATCL had averaged a higher score and been in the top 3 applicants, it would have received a dispensary license in Summit County. That is clearly prejudice. If we had scored higher, we would have gotten a license. And the reason that we didn't have an average score that was higher was because the questions were scored inconsistently. It's set forth on page 21 of our appellate brief. If you made the scores that the state awarded ATCL, if you made those scores consistent, it would increase the average by 5.893 points, which would have put ATCL in 3rd place. And they would have qualified for a dispensary license in Summit County. It's important to note as well that...
Let me stop you just for a second. Does that also account for adjusting the scores of the competition, or just for ATCL?
That accounts for adjusting ATCL scores.
But did you offer any evidence on what happened to the 4 that outperformed you on the test, according to the grading as it took place? Because I assume that they had the same problem that you did.
In the record, it did not analyze if you increased or lowered the scores of every other applicant, but it's important to note that the state in this awarding process set aside 60 dispensary licenses that they could have awarded. They only awarded 57, meaning that if ATCL were awarded a license, it wouldn't prejudice any of the other applicants and wouldn't take away a license from any of the other applicants. It's also important to note that, as this court knows, that the Court of Appeals standard for reviewing the trial court's decision is an abuse of discretion standard. That's a very high standard for the state to meet in this appeal. The trial court did not abuse its discretion in finding that the board's decision to uphold its denial of a dispensary license to ATCL lacked reliable, probative, or substantial evidence. A trial court standard of review for an appeal of an administrative order under revised code section 119.12M is that a trial court may reverse, vacate, or modify the order unless the order is found to be supported by reliable, probative, and substantial evidence. The state did not show in the underlying case that its inconsistent scoring was supported by reliable, probative, or substantial evidence, or that the board's decision to uphold that inconsistent scoring was supported by such evidence. The trial court properly found that the hearing officer who conducted the administrative appeal hearing made an improper inference unsupported by the record that the scoring inconsistencies may have been caused by formatting differences, or that the evaluators may have compared applications across districts. The state has not addressed in their brief, nor today, those improper inferences by the hearing examiner. Further, in its brief, the state argues that the trial court abuses its discretion by remanding the scoring back to the board. And in its brief, the state argues that it will be difficult for the state to rescore ATCL's application because the same examiners may not be available, for example. However, we would say that whether or not the exact same examiners are available now or not does not justify the state ignoring its own rules to consistently score the applications. Further, it's speculative to assume that if you have new examiners that they won't consistently score the applications. In the Buckeye relief case, the remedy that was applied in that case was to remand the scoring back to the board, which is what the trial court properly did here. Further, if it is in fact impossible for the state to rescore the applications, which we don't concede, they could adjust the current scoring, as we've suggested in our brief, and that scoring was done by the evaluators who were present at the time. As I indicated, if you adjust the scoring, as we've suggested, ATCL would receive a license in Summit County. And there are still at least 3 dispensary licenses available that were not awarded to other applicants. For all these reasons, this court should uphold the trial court's decision, and the state should go back and rescore ATCL's application consistently in accordance with its own rules. Thank you, Your Honors.
The remand order doesn't require the board to rescore the other applicants' test too, does it? Just yours?
It requires rescoring ours.
Just yours.
Thank you.
Thank you, counsel. Mr. O'Connell, you have 4 minutes and 31 seconds remaining for your report.
I have a lot to say, and I can talk fast, but I'll try not to. I just want to start with the Dennis-Clarko matter, because I think that's very important. The Dennis-Clarko standard is the proper standard, and Buckeye Relief did not rule on what standard applied. What it said was, regardless of what standard applied, there should be relief in that case. They expressly said that would be left to another day. So they just said the violation was so serious that under either standard it would be a violation. We also have this issue, why are we asking to remand the case to rescore the entire application? First off, the judge is very vague. Is it rescoring or just reevaluating? And, is the board going to look at it and then say, well, there's this error, we're going to reevaluate the prejudice? Or are they saying, no, you've got to bring back the original evaluators, including the guy with Parkinson's disease, who even as of 3 years ago, said he didn't have enough memory to testify. How about the people who have moved out of state? The guy who has one of the evaluators, when we went to try to have him rescore on Buckeye Relief, he just basically, looked out the door of the people as they tried to serve a subpoena on him. How are we going to get people, retired employees, and people who are retired, and people where we don't know where they are, how to come back? Are we have to get new people? Where are we going to find them? There's no way we can train them exactly the same. And why would we score the entire application when some of the questions did have different answers? Their floor plans were different. Their amount of funding for each of those locations had different sources of funding. There were a number of questions that, by necessity, were different. But we're getting beyond we're getting too far ahead on that issue. We shouldn't have to remand at all. The real question is going to be, is there error and is there prejudice? If ATCL has made a record to you that there is error and prejudice, then the proper remedy is to order the board to award them the license. Sending that for remand is not necessary or required, and in fact, somewhat illogical as a jurisprudential matter, because you typically, when a court remands, they'll remand it to an adjudicative body. But scoring is not an adjudicative body. You'd be remanding to the hearing, to the board, possibly hold a hearing officer, have a new hearing. But having set back one more step to where the scoring happened, kind of a staff level decision in a way, that's just not the way remands usually work. I also think it's very important to look at the legal standards here. They're emphasizing that the standard on appeal to your court is abuse of discretion, but that's only for issues of fact. And in this case, all the material facts are undisputed. So if the material facts are undisputed, the abuse of discretion is not relevant. The real standard here is de novo, because whether something's in accordance with law, on review to this court is a de novo review. In fact, the court below, it's somewhat odd why the court said that it wasn't supported by reliable, probative, and substantial evidence, because you had no dispute of material facts. if there's no dispute of material facts, then there's no reason to, there's no reason to be issuing that ruling at all. As the Ohio Supreme Court recognized, on an administrative appeal, if all the facts are undisputed, the decision has to be as a matter of law. And finally, I do want to point out that Aaron Reed, what she testified to, was that the evaluators were trained with steps to try to minimize discrepancies, and that ideally that they wouldn't have any. But just because Aaron Reed said that was one of their goals, doesn't mean it's in the request for applications. It doesn't make a requirement that they have to have perfect execution in order to have a process be applied. And with, frankly, a first of its kind in the state, request for applications for licenses, where they're making it up they're making up the process from scratch, you had to expect there was gonna be a few stumbles and hiccups. You just have to know that something will happen. What the real question is the board apply it fairly? Did they try to be fair? Did they comply with the RFA? And if they did make a mistake, was the mistake big enough to make a difference that the applicant should have won a license?
And thank you, counsel. With that, I believe you've utilized your 15 minutes.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk of courts on the decision on the day it is released. Also, you can find the opinions posted on the Ohio Supreme Court website once they are released.